Everybody, welcome back to a new post today. Let's today look at the week 3 of polity and governance topics for the UPSC 2026 examination, which is very important from Jan 18 to 24th. Let's touch on few important topics today, which really made important news for your polity and governance. And the very first one is about the protests now with regard to the Vadhavan port in Maharashtra. This intensified with thousands of locals, including fisher folks, Adivasis, farmers demanding the immediate scrapping of a mega project in Palghar, Maharashtra. Now, there have been massive mobilizations on January 19th and 28th. Approximately 20 to 25,000 people have marched to the Palghar district collectorate, and it was organized by the CPI along with the All India Kisan Sabha, starting from Charoti village, concluding at the collector's office. And the Vadhavan Bandar Virodhi Sangharsh Samiti, which has resisted the project for decades, held separate rallies as well. It brought a disruption to the Mumbai-Ahmedabad highway, which led to closure of shops. So what are the primary reasons for this? First of all, the fisher folk fear golden fish belt, a major breeding ground for lobsters and pomfret, will be destroyed by sea reclamation and backwaters. Activists argue that the project violates the 1998 order declaring Dahanu an eco-sensitive area, and it also causes irreparable damage to the marine and the coastal ecosystems. The protesters allege that the government ignored the objections raised by the public hearings, that the social and environmental impact assessments were flawed, and the port has been a part of a larger, unwelcome fourth Mumbai plan that includes a bullet train, freight corridors, expressways leading to mass displacement. Despite the opposition, the government maintains that the 76,000 crore project is vital for India's economic growth. And the project, conceived by the Union Cabinet in 2024, is intended to make one of the world's top 10 ports. Apart from that, the government claims clearances have been granted, and the protesters have filed appeals in Supreme Court arguing that construction should not proceed while the matter is sub judice. So this is one of the major issues. The next one is about Supreme Court staying a Rajasthan High Court order that has mandated the removal or relocation of 1,100 liquor outlets within 500 meters of national and state highway. A bench comprising Justices Vikram Nath and Sandeep Mehta issued a stay providing temporary relief to the liquor shop holders and the Rajasthan government, while being acknowledged that the concerns regarding road safety and drunk driving deaths are absolutely genuine. It noted that sweeping directions require closer scrutiny, especially given previous Supreme Court rulings. And the legal arguments put forward are that the Supreme Court previously clarified that in 2016, highway liquor ban does not apply to licensed vend within the municipal areas. The High Court orders had applied a blanket ban regardless of the municipal limits. And the state government argued that shutting down these shops would result in revenue loss of 2,200 crore, which would cause significant practical difficulties in urban areas where highway pass directly through the towns. And the petitioners argued that the High Court passed a statewide order ban on the PIL concerning only few shops in Sujangarh without hearing the affected stakeholders. Apart from that, the original Rajasthan High Court, the background of the case includes where the Rajasthan High Court order was in response to a PIL filed by residents of the area fighting a fatal rise in the road accidents linked to easily availability of alcohol in the highways. The High Court had criticized the state for creating liquor-friendly corridors and gave a 2-month deadline for the relocation. However, the Supreme Court overturned the Rajasthan High Court order. And now the top court has flagged the exorbitant surge in airfares during festivals and called it as exploitative. The plea pointed out that currently there is no regulatory authority to review and cap the airfares. The Supreme Court recently slammed the exploitative surge in airfares during the festivals, with the bench observing that the ticket prices often triple during peak periods like Kumbh Mela. The bench, consisting of Vikram Nath and Sandeep Mehta, flagged that the current algorithm-driven dynamic pricing of day-to-day travel surcharges unfairly burden the passengers, especially those travelling for emergencies or work. The PIL Act filed by activist Lakshmi Narayanan emphasizes that no statutory authority currently exists to review or cap the domestic airfares, allowing the airlines to operate with opaque pricing. And the petition also challenges the reduction in free emergency check-in of baggage allowance from 25 to 15 kgs, reviewing it as a way to turn the basic services into revenue streams for the government. The plea argues that air travel should be treated as an essential service under the Essential Services Maintenance Act of 1981, similar to railways and postal services as well. And the court has directed the Ministry of Civil Aviation and Directorate to file detailed responses regarding the establishment of binding authorities and guidelines as well. Now, the Election Commission of India is going to host the inaugural India International Conference on Democracy and Election Management from January 21st to 23rd at the Bharat Mandapam. The conference is going to be hosted by ECI, organized by the India International Institute of Democracy and Elections. The agenda is democracy for inclusive, peaceful, resilient, sustainable world, continuing India's chairship of the Council of Member States of International IDEA for 2026. The event brings together 100 international delegates, 70 countries and 40 election bodies across the world. And the outcome will adopt the Delhi Declaration of 2026, marking India's chairship of the body called as IDEA, which means the Council of the Council of Member States of the International IDEA for 2026. Apart from that, we have the discussions titling India's elections up to 2024 as well. That was screened for the delegates. Now, the Prime Minister has inaugurated an elevated corridor in Assam's Nagaon district. The corridor is designed to balance infrastructure development with wildlife conservation, providing safe passage for animals like one-horned rhinoceros, very famous in Kaziranga, and elephants during the monsoon floods. It is 86.6 kilometer, 4-laning project for Kaliabo to Numaligarh section on National Highway 715, and it is passing through Kaziranga National Park and Tiger Reserve. Also, the project is expected to reduce the travel time between Upper and Lower Assam by nearly 1 hour, boosting ecotourism and also regional industries related to the Numaligarh refinery. Construction will be handled by the National Highways Infrastructure Development Corporation and is slated for completion within 36 months. Apart from that, we have Prime Minister also flagging off the Amrit Bharat trains to enhance long-distance connectivity between Dibrugarh to Gomti Nagar in Lucknow and Kamakhya Guwahati to Rohtak. Supreme Court uses its powers under Article 142, which calls for vacant positions in the higher education institutions to be filled in 4 months, in a very significant view to reduce the chronic shortage of faculty and improve the student well-being in higher education institutes. Supreme Court of India has invoked its plenary powers under Article 142, mandating the filling of all vacant teaching and non-teaching positions within 4 months. The order was given by benches Justice Pardiwala and Madhavan in January, following reports from the National Task Force recording high number of student suicides and systematic deficiencies in the higher education institutes of India. Now, the Supreme Court has given several directives like a 4-month deadline for filling the vacant teaching and non-teaching positions in both public and private higher education institutions, mandating that the key administrative positions like Vice Chancellor, registrars be filled within 1 month, prioritizing positions reserved for marginalized communities, allowing special recruitment drives to clear the backlogs, and requiring the institutions to submit annual reports on vacancies and recruitment progress as well. The Supreme Court has connected the staff shortages to student distress, noting that the overburdened staff and administrative vacancies contribute to a structural stressor identified in the report on student suicides. The court stressed the importance of proactive recruitment given the retirement dates to be known in advance. And a very important split verdict in a case with regard to Prevention of Corruption Act and its amended provision, especially with regard to Section 17A of the Prevention of Corruption Act. So, in January 13, the 2-judge bench of the Supreme Court comprising B.V. Nagaratna and Justice K.V. Vishwanathan gave a split verdict on a challenge to the constitutional validity of Section 17A, while one judge said it should be removed, the other said it should stay for the governance to be carried on. And the case is the Centre for Public Interest Litigation versus Union of India. Both the judgments, the case had challenged the constitutional validity of the section that provided that no police officer can conduct an inquiry or an investigation on a public servant without the prior approval of the government, that is the executive. Now, the premise is based on that corruption is an anathema to the rule of law. Anathema means something which is bad or vehemently disliked. So vesting the government with the power to stall corruption investigation and also making corruption go uninvestigated and unchecked as well. Now, in this case, the petitioners argued that the amended section was unconstitutional, being in teeth with the earlier judgments of the Supreme Court, like the Vineet Narayan versus Union of India case, where the Supreme Court had held that the final opinion whether to investigate the officer has to be taken by CBI and not the executive. Apart from that, in the Vineet Narayan case, the central government also enacted the Central Vigilance Commission Act and introduced another section 6A to the Delhi Special Police Establish Act, reintroducing something called as a single directive, where it is a set of instructions issued to the CBI or CBI by various ministries or departments. Now, the constitutional bench of Subramaniam Swamy versus the director CBI declared section 6A of the Delhi Special Police Establishment Act unconstitutional. However, now the case deals with that the section runs contrary to the previous directives of the Supreme Court, which mandates that the registration of the FIR and consequent investigation on should be carried out on disclosure of an offence by a public officer. Nagaratna upheld that deleting the section will uphold the rule of law and also deal with corruption, while the other judge, that is Vishwanathan, says that striking down the section would lead to policy paralysis. He felt that honest persons needed to be protected from frivolous investigations. At the core of the disagreement between the two judges is how to strike a balance between protecting honest decision-making public servants and also ensuring an efficient anti-corruption regime, which means good governance as well. So the matter has been referred to the Chief Justice of India for constitution of a larger bench now to decide the issue conclusively, which had a split verdict. So these are the most important points I thought I should be discussing with you all for polity and governance in the next week, coming up with much more because of the budget to be introduced. And if you did, please do like, share and subscribe, and don't forget to comment at the end of the video. I shall see you in the new post. Until then, it's very happy learning.